Difference between a lease and a live-in license. This is one of the favorite questions of all the legal heads the moment the discussion comes about working upon real estate matters. Of course, if you're giving an interview for a proper real estate position, then this answer may not apply. However, for a beginner or for a general commercial legal role, knowing this answer should suffice. Here, I will cover the similarities between the two and the actual difference or a pragmatic answer of differences between the two. I have not covered the theoretical differences, the reason being because that is something which can anyways be easily found on Google and can be mucked up. However, a word of caution, in one of the legal interviews, a legal head wanted me to recite the definition of lease and live-in license as it is. So, depending upon the level of eccentricity the person is looking for, it can depend upon the answer they are expecting can vary. Now, before we start with the differences, let's just first understand the concept. And to understand the concept, maybe it is essential that we understand the similarity between two. Essentially, what is a lease or a leave and license agreement? It is basically a form of agreement by which you take a property, commercial or residential, from the owner of property for your use. The use will be something which will be restricted as per the terms of the agreement. What amount you will pay in return to the person from whom you are taking the property will be the compensation. So as I mentioned, in order to appreciate or really understand the differences between the two, it is essential to first start with understanding the similarities between the two, which will give a conceptual clarity. So now let us begin with an example. Suppose you want to take a property on rent from someone for your use, which can be a residential use. Now, what happens in such a case? There are three things involved. First, there are two parties. The parties are one, the owner of the property, and the second party is you, who is desirous of taking that property from the owner for your use on temporary basis. Now, of course, when you're taking a property from someone, the person will not give you a property for free. The person would expect a compensation in return of giving that property. So that is the third element. Basically, there are two parties. One, the owner. Second party, the person who is desirous of taking that property from owner for temporary use. And third thing involved is the compensation which the person who is taking that property from owner will give in return of using that property. Now, the underlying factor here is what remains common is that the person who is taking the property on rent is getting a right to access the property in return of payment of compensation of money. Now, a very pragmatic or a one line answer of differences between the two is that in case of leave and license, what is given is actually just the license to access the property. I will elaborate further on this. The way when you want to do certain things, so for example, you have a driving license which allows you to do certain things under certain restrictions. Or to give a better example, a factory has a manufacturing license which allows the factory to produce certain goods and products. Now, the way government gives a license, similarly, in case of a leave and license, the owner of the property grants a license to the person taking property on leave and license basis to access the property. That's it. In case of leave and license, you do not get any other right in the property. While in case of lease, there is a temporary transfer of right to enjoy the property, which means that lease is a much more permanent way of getting a property on temporary basis. While in both the cases, of course, the property is given on temporary basis, but in case of lease, there is a heritable interest There is an interest created in property. If suppose something was being done to the property, the lessor, the person who has taken the property on rent, also has the right to say and to protect the property. I'll elaborate further on this. But the basic differences between the two is that a leave-in license only grants you a license to access the property. Now, before we move forward, just a quick introduction to the basic terminology between the two. In case of leave-in license, the the person who is giving property on rent is called the licensor. The person who is taking it is called licensee, and the compensation which is paid is called license fee. In case of lease, the owner of the property is called lessor. The person who is taking property from the lessor on lease is called lessee, and the compensation is called as rent. An easy way to remember this is owner ends with er, licensor ends with or, and lessor ends with or. So I think that once you remember licensor, lessor, owner, the other terminology just follows in your head. Now coming to the heart of the question, what is the difference between the two? As I explained, in case of leave and license, the basic nature of right which is created is by way of a license, which is permission to occupy the property. There is no exclusive possession of the property which is granted. In case of lease, of course, a person gets a right in the property. Then, in case of leave and license, there is uh, there is actually, in theory, no actual transfer of possession. The possession of the property still remains with the owner. The owner is only granting you, which is the licensee in this case, which is the licensee in case of leave and license, a right to access the property. The possession of the property is still with the owner, but you have the right to occupy and use the property. While in case of lease, you are actually getting a possession of the property. There, this is something which can never be seen in a practical aspect or in practice, but this is something which is a theoretical difference between the two and a major difference. Then, as I mentioned earlier, in case of lease, there is a stake or interest in the property. So suppose tomorrow if the government was suppose the person has taken a property on lease from a lessor for a period of 15 years. There are some unpaid government dues on account of that property. Now, the person who has taken the property on the rent, which is the lessee also has the right to go and get those dues paid, so that government does not take any action against the property, because the lessee has a stake or interest in the property. Now, this we have already seen that the compensation which is paid is called license fee in case of a leave-in license, and in case of lease, it's called as rent. One very important differentiating factor between the two is that the Indian Easement Act determines leave-in license, or not determines, it's the governing law is the Indian Easement Act, while for lease, the governing law is Transfer of Property Act. Generally, in case of if a property is being taken on leave-in license, a construction will be allowed on the property. A construction will not be allowed on the property, while in case of lease, it will be allowed. One more very important difference is that a leave-in license is generally for a shorter duration, generally for a period of 11 months to 5 years, while a lease is for usually more than 5 years, and it can be something as long as 99 years as well. Now, whether or not the interest is heritable. Now, this is something which is again related, in fact, to the previous question, which is whether or not there is an interest in the property. So, in case of leave and license, because there is a tangible interest which is not created, there is no heritable right. In case of lease, yes, there is a heritable right. Now, these are very practical aspects of it, that leave and license is generally used in case of renting of apartments, while lease is generally used for commercial premises such as factory or corporate office. And the reason is plain and simple, that in case a person is taking a factory on lease on a rental basis, the person who is going to make uh, certain long-term investments there in certain construction, etc. So obviously it makes sense to have a property on lease rather than on given license. Now, what is the final verdict? Which one should you go for? So if you are the owner of the property, you would always want to give the property on leave and license basis. The reason being, you are more in control of the property. While if you are not the owner of the property and you are the person who is taking property on rent, when you are a tenant, you would always want to take it on lease, because then your rights are superior. However, in both the cases, there are other aspects also to be considered, which are completely or mostly commercial. And one of the major other another aspect is the stamp duty payment. In case of live and life, stamp duty is generally lower. In case of lease, it is